So good morning, everyone, and welcome to the Catapult series here at Innovate Durban. This is, I think, the sixth of the edition that we've been hosting. I just want to introduce joining us today. We have our CEO, Aurelia Albert. We have Nosipo, who's our projects and events coordinator, and we are joined by our industry expert today, which is Vishen Pillay, who is a partner at Adams & Adams. So just introduce Innovate Durban for those of you that are joining us for the first time. Innovate Durban is a special purpose vehicle that was set up to support innovators, innovation, and the innovation ecosystem through our various projects and programs. Is our innovation support program, capacity building and skills development, as well as research. We have a number of platforms, virtual and physical, that also support these activities. We have earlier this year launched our Innovation Collab. You would have seen in the slides preceding the start some of the facilities that are available through our Innovation Collab, which were set up as the first township lab that allowed access to the community. We're very excited to have run this over the time and really grateful to all the industry experts that joined us over the last few months. It's really been valuable in terms of extending the support that we offer to our innovators, to the larger communities, that is to businesses as well as entrepreneurs as well. Just some housekeeping rules for today. I do want to share some information that in terms of question and answers. So our Q&A function is enabled. So you're welcome through the presentation to post any questions that you might have. These will be answered in the Q&A session following the presentation at the end of the session. You can also raise your hand because the raise hand function is available should there be any issues during the course and you're unable to use the Q&A function. The session is set to be an hour long, and so we're hoping to stick to that time as well. If there's anything that can't be answered during the Q&A, we'd be happy to also then during the rest of the session to be able to answer in terms of offline correspondence via email. I just wanted to share a little bit of information on our industry expert today, Vishen, who's also a longtime partner of Innovate Durban. So Vishen is a partner in the patent department of Adams & Adams Attorneys, which is the largest IP law firm in. He has a background in electronic engineering through UKZN and is also an admitted attorney as well as a qualified patent attorney. He has approximately 15 years of experience in IP, 11 of which is a post-qualification experience. And he specializes in assisting his clients to protect their inventions in various sectors, including electronics, software, artificial intelligence, quantum communication, computing, telecommunications, as well as biomedical engineering. So in particular, he deals with all matters relating to the filing and prosecuting of patent and design applications in South Africa and abroad, as well as IP strategy. So I'd like to hand over to Vishen. Like I said, you're welcome to, during the session, to post any questions you have using the Q&A function. Thank you.
Thank you for that introduction, Suzanne. Just let me have a look. Can you see my screen?
Yes, we can.
Okay. Okay. Is the main screen up? It's intellectual property. Can you see the presentation?
I'm
just moving through it.
No.
Okay. No. Let's try that again. Okay, let's just try it. Okay.
It's not sharing, Vishen, at the moment.
I'm just trying to figure out what's going on here, Suzanne. It was working when we tested it. I don't know what happened. This way, yeah. Okay, share screen again.
So if you can give us a few minutes, guys, and I'm sure we'll start shortly.
Yeah, sorry, I'm not sure what's going on. Let me just try to reopen it.
I think even if you share your screen and then you your desktop and then from there open it, it will allow you to.
Yeah, I think so. Let me just do that.
Yeah.
It's not even letting me do. Let me
100%.
quickly try it again. Okay, let's try it again. Okay.
Okay, it seems to be starting.
Okay, can you see the main page, Suzanne?
Not as yet. It's sharing your screen. It's starting to share your screen now. Yeah.
Okay. Can you see the main page saying intellectual property?
Not as yet.
Okay. Yep. How about now?
No, we can't. Alternately, do you want to start with the presentation? We can always send it through to, and I can also try and share it in the interim. If you do want to
let me.
with an overview.
Yeah, let me. Yeah, I think I'm struggling to share this. It's just, not sure what's going on.
I think, yeah, if you just want to maybe give us an overview in terms of the, and I can also share it for you and you can just let me know. And yeah, would you prefer if I just shared it and you could just tell me when to get to the next screen and then, I'm just checking if everyone can see that. Nasipo and Aurelia.
Yes, I can see it.
Okay. Yes. Is that fine, Vishen? You can just say next and I'll move on. Sorry, I know we just tested it, but these are the challenges we have. And I'm sure we can catch up on the few minutes that we've lost as well. 100%.
Yeah, no, I'll go as quick as possible, Suzanne. Thanks.
No stress. We'll also email the presentation to those that are logged on as well.
Okay, perfect. Yeah, so sorry about that all. We did test it earlier and technology works when it works. It's great if it doesn't. We have this issue. But today we're going to chat about intellectual property. And I'm sure that many of you have heard or have heard the term intellectual property. But when we talk about intellectual property, it's not just one thing that we're talking about. It's actually an umbrella term that we use to describe a whole range of different rights. And it includes trademarks, copyrights, patents, registered designs, know-how, trade secrets, plant breeders' rights, etc. Now, in this presentation, I'm not going to touch too much on plant breeders' rights, know-how, and trade secrets. But I think plant breeders' rights are almost self-explanatory. If you are creating new varieties of plants, etc., this is where you can protect yourself, especially if you're coming up with new strains of plants, etc. Trade secrets and know-how times. Trade secrets is exactly like the secret formulation for Coca-Cola and the 11 herbs and spices of Colonel Sanders and KFC. That's what we talk about when we refer to trade secrets. There's no specific thing that you would register to get a trade secret. It's just that you don't tell anyone what it is that you're doing. You keep it as is, or you'd only try to protect it by way of confidentiality agreements and so forth. So it's a strict need to know basis. Know in a specific way or create a product in a specific way. If you don't tell anyone about it, you keep it as a trade secret. So those forms of IP, which is know-how and trade secrets, is not registrable. It's just that you need to make sure that you are buttoning down whoever needs to know about it with confidentiality agreements, etc., and trademarks.
Yeah.
So next,
yeah, 100%. I'm gonna switch. If you can switch your video off,
Suzanne.
Yeah,
Sorry, Suzanne.
Yeah, if you can switch your video off.
Sorry, Suzanne. Next slide, please.
Yeah, Vishen, can you switch your video off because your sound is breaking up a bit. So if you can do that. Alternatively, what I am going to do is I'm actually going to allow you to present by calling you, and then you can just go through the presentation that way, if you could do that. Yeah, and then you can switch your sound off on your side. I'm just going to call you quickly, I think just for the benefit of everyone, and then we can do it that way, because I think there is a problem with the connection as well. So I'm just calling you now. If you can just, and I'll got you on speaker, and then you can present using that. If you can just mute your yes, I can hear you. I just want to make sure that it's clear to everyone else. I don't think it's going to work this way. Okay, if you can just switch off your video, Vishen, and then I will start. I'm moving to the next slide, and then hopefully it works out.
Okay, can you hear me now, Suzanne, hopefully?
Yes, I can. I can hear you clearly. Yeah, if you switch your video off, and I think maybe just limit your movement. I don't know why, because we tested all of this earlier and it seemed to be working at that point. Yeah.
Yeah, I can't explain it. You know, networks and but yeah, so I'm going to just touch on patents now. So as I mentioned, when we talk about intellectual property, we're not just talking about one right. We're talking about a collection of different rights. And patents are one of those rights. But what a patent is effectively a legal invention. And an invention can be anything. It could be a new apparatus, a new product, an article, machine, method of doing something. And you'll see that the common denominator in all of these is the aspect of novelty, which is new. And it can be patented. Next slide, please, Suzanne. And you know, when we talk about what or the requirements for patentability, the invention needs, or any invention that you come up with that is new, needs to meet the requirements of patentability, in that it needs to be of suitable subject matter, because certain things cannot be patented. it also needs to be new and inventive and capable of use in trade and industry or agriculture. Most inventions are capable of being used in trade and industry or agriculture, so it's not such a major issue. But the main aspects whenever dealing with any new invention is the aspects of novelty and inventive step. So the first thing, if you come up with any new technology or new product, you have to ask yourself, is it new? And that when you ask yourself, is it new? It needs to be a global question when we're talking about patents. It needs to be a world first in order to be patentable. And even if the invention is a world first, the second test kicks in is that it needs to be inventive, which means that it must not be obvious to a person skilled in the field of invention to come up with the same solution or product that you have. And that's basically the main requirements for patentability, which is novelty and inventive step. As part of the requirement of novelty, it's imperative that you yourself keep your invention strictly confidential until you've decided whether or not to seek patent protection for it. Once you tell people about your invention and you don't have a non-disclosure agreement or a confidentiality agreement in place, it's done and dusted. It's very difficult to go back now and then file a patent for your invention. So the main rule is that if you're coming up with something new or a great idea, let's put it that way, and it's a world first, rather seek some advice to see whether or not it's worthwhile you trying to protect it. Next slide, please, Suzanne. Thanks. So as I mentioned, in order to be patentable, an invention needs to be suitable subject matter. And this generally varies from country to country. In South Africa, there are certain things that cannot be patented. So for instance, if you come up with a discovery, a scientific theory, mathematical method, etc., all these things listed here cannot be patented as such. Now, interestingly, you'll notice that computer programs are listed there. But next slide, please, Suzanne. But insofar as computer programs is concerned, as well as all those exclusions, is that it varies from country to country. So South Africa has all those lists of exclusions, including computer software and methods of treatment, etc. Other countries like the US don't have those lists of exclusions. So it's important to bear in mind. And also the list of exclusions that I mentioned vary from country to country. I touched on computer software because it's something that my practice deals with quite a lot. But computer software is not patentable in Europe, for instance, as such. But if it has some sort of a technical effect, if your computer software or your app is controlling something, it has a real world interaction in that it controls a device, or it has, like any sort of a human or physical interaction with the machine. That's when it elevates beyond just being a computer software, and you can protect it. So an easy way to almost conceptualize what I'm trying to say is that Uber's, Uber, you think of just being an app, but actually if they file a patent for it, what the patent would cover is the system where you would have a requesting user sending a message to the server, which receives the message, looks at the geophysical location, matches it with the driver, and facilitates that engagement. That is what the patent would be. So bear in mind that although the software or the app itself cannot be protected, you can actually protect an architecture that it resides within. Insofar as South Africa is concerned, we do have those exclusions as mentioned, but like I also said, it's excluded as such. So whenever you have any invention that falls into the category of being a world first, it's perhaps something to get some advice on to determine whether or not it's worthwhile protecting. Next slide, please, Suzanne. So the process in South Africa, and when you determining whether or not you have something that's a world first, the good step would be to conduct searches. So go online, go to websites like Google Patents, Free Patents Online, etc., to try to see whether or not somebody has thought of your idea. And the reason why I'm directing you to patent websites is that odds are, the way the world works is that if somebody created something, they would have tried to protect it by way of a patent. So patent documents have a lot of technical information and knowledge that can be found at a single source. So that's why it's good to conduct patent searches. So let's just assume that you conducted your patent searches, you've consulted with a patent attorney, and you decided, look, you want to actually protect this invention. The next step is what we're looking at here, and it's to file something called a provisional patent application. The provisional application secures your rights to the invention worldwide for a period of 12 months. At the end of that 12-month period, you then have to file something called a complete patent application, which then proceeds through to acceptance and grant automatically in South Africa. As I mentioned, that this timeline here is predominantly, it's just a South African approach. And the reason why I say that is that South Africa doesn't examine a patent for novelty and inventive step, etc. So if you follow this process, you file your provisional patent, you file your complete patent, it's going to proceed through to acceptance and grant automatically in South Africa. The only time that somebody is going to question your patent is whether or not you take it to court, meaning that you try to litigate on this patent or you sue somebody, or somebody attacks the patent for whatever reason. And that's when the courtroom becomes this examining office where they examine the patents, etc. So the bottom line when you're dealing with this entire process is that in South Africa, there's no examination. You have to file, when you file your provisional, you file your complete, you get your granted patent. The lifespan of the patent from the time you file your complete patent is 20 years, and you only get protection in the country that you actually file a patent for. So it's important to remember that patents are territorial in nature. And next slide, please, Suzanne. And this slide here brings it in perspective in terms of international protection. If your scope of your invention is wider than South Africa, and you'd expect that you would have, I would say, there's an opportunity for you to explore outside of South Africa's borders, you have to file patent applications for these countries that you want protection in that 12-month period. And when I say that it could take 1 to 10 years to grant, it's because all other countries outside of South Africa and a few other countries actually examine patent applications to see whether or not it's a world first, whether it's obvious or not, in order to grant it. So you can understand that there's a bit of to and fro with the examiners. Normally, patents are relatively inexpensive in South Africa. When I say relatively, it is still fairly costly, but it's probably around 20 to about 30,000 Rand for a provisional patent application. Foreign applications are where the big costs come in. If you file a patent application in the US, you're spending between 50 and 70,000 Rand. You file an application in Europe, you're looking at 80 to 100,000 Rand. So that's where the big costs come in patents. To file a patent in South Africa, a complete patent after you file a South African provisional, it's roughly around the same cost as you file the provisional. So it's between 20 and 30,000 Rand. Next slide, please, Suzanne. So a strategy that's used often to extend the period of time for patent protection is to file something called a PCT application. It effectively takes this provisional application, which I mentioned is covering your rights worldwide for 12 months, and it extends it out by a further 18 months in 155 odd countries to then delay these costs that you have to incur by effectively 2.5 years. So if you file your provisional application, you file your PCT application, you're effectively buying yourself 2.5 years with patent pending in about 155 countries in which to explore your markets. And odds are within that 2.5 years, you should have a reasonable likelihood of the commercial success of the project and to decide whether or not it's worthwhile spending more money down the line. And that's, so the PCT has a delay strategy and delaying of costs. And the other benefit is that you would have in that 2.5 years, an independent search and examination being conducted on your invention, meaning that somebody is going to pick this application up and review it to see whether it's world first or an inventive. And they don't necessarily grant it, but it gives you almost an independent opinion of whether or not you should be proceeding with it. So if an examination report comes out and it's very positive, it gives you a good indication that you're going to have success if you try to patent in other countries. But on the flip side, if the examiners find something that really knocks your invention out of the water, then at least you can limit your costs by then saying to yourself that, look, there's no merit in proceeding with it, and let's just hang up the hat there. Next slide, please, Suzanne. So the question always comes up is that now that you have a granted patent, what then? Now, I think in most people's minds, the patent would be, of course, to stop people from doing certain things. And the rights that patents give you in most countries around the world is to stop others from making, using, exercising, offering to sell, and importing that particular patent in a country. I like to think of a patent as a bubble around a country that you get protection in. in that you're not allowed to make, use, etc. that technology within that country, and also you stop people from entering into that borders of the country by way of importation. In addition to the usual benefit of stopping people from entering into a space, there's of course the other aspects of patents, which is of course the licensing aspect, where you can license your patent if you don't want to use it to other parties to use. There was always a joke that IBM used to make a lot more money than Apple when they initially sold their Apple Macs, because of the licensed technology that that Apple actually uses in their Macs. So licensing can generate a lot of third stream revenue. So we have, for instance, clients that will file patents in the US, not even having a base there, but what they do it for is to just get a third stream revenue in the form of licensing fees coming in. Then, of course, is the sale value in selling patents. Some technologies have become very valuable over time. And the value in it can be captured in a patent. Excuse me. So there's, of course, the sale value in having it. And then the last factor is of course, the scare value in having a patent. When people see a patented, or when people see a patented technology, they immediately think, or they immediately start to think that, look, I'd rather not enter into the space because I'm going to get slapped with a lawsuit. So there's of course that benefit with a patent. Next slide, please, Suzanne. In terms of what you can actually get if you sue somebody successfully in South Africa is an interdict, meaning that you can stop people from infringing your technologies or copying your whatever it is that you're doing. If they make products that are infringing your products, you can ask them to deliver it up to you for destruction. And then of course it's damages, and damages are what you'd see. So effectively what they would have paid as a reasonable royalty to you for being a licensee of yours, that's what they would pay as damages. So you can appreciate that the benefits that you can get if you're successful is quite powerful. Next slide, please, Suzanne. Thanks. This is just an example, a practical example of a real world example, or a real world technology patent. And it's based on a research project into internet search engines that was taken in '96 by Larry Page and Sergey Brin. So at that time, internet searches were really bad. And I remember doing a search, and it was a hit and miss when you tried to find something. And that was because the websites at the time, or the search engines at the time, counted the number of times that a particular search key was referenced in a website. And that's when they would give you a result. But these students found that, and they were research students, so they found that if you rank websites in a similar way you'd rank research papers, in that the websites that are referenced the most get the most weighting, it would be a better way to rank websites. And they called this a PageRank algorithm, and they filed a patent for it. And next page, please, Suzanne. And what they effectively managed to do is that they filed a patent for the technology, and they got a granted patent, and they went on to form one of the most successful companies in the world. And I think that there's not anyone of us here on this call that doesn't know or hasn't heard and hasn't used Google. So Google's strength and power today is based on one patent when they were research students at Stanford University. Next page, please. Thanks. So there's a few takeaways from the story of Google, which I'd like to share, especially if you're working in the software space or if you're from a university background, is that even though you invent something, it doesn't necessarily mean you own it. So if you're working for a company, or if you're a PhD student at the university, odds are you don't own that invention. It's your company or the university that owns it. So that's why up to this day, even though it's the core of Google's technology, it's not actually owned by Google. It's still owned by Stanford University. However, in exchange for an exclusive license agreement, meaning that only Google can use that patent, Stanford University receives yearly royalties. And in addition to that, it received quite a lot of Google stock. So in addition to the millions of dollars that they receive in terms of royalty fees, they sold their stock in 2005 for $336 million. If you do a rough calculation, even by 15 years later standards, that is a tremendous sum of money. So you can understand the value that one can unlock just with one single patent. Next page, please, Suzanne. So the next form of IP that we always refer to, and it's very closely related to patents, is registered designs. Now, registered designs, whereas patents protect what is new and inventive, irrespective of the way that it looks, registered designs, on the other hand, protects appearance of an article. And there is an overlap between patents, because whereas the patents will protect the novel and inventive aspects to a particular technology, registered designs protect the way that it looks. So you could have an invention, let's just say you invented the car, but I can have a car that looks very different from yours. So I will have protection, I can get protection for the way that my car looks, and you can get protection for the way your car looks. And so you can, so that is where the overlap comes in. And the reason why you file for both is that it's just another asset that you can add on for protection. And that's the way that one should look at the overlapping IP rights in terms of technology. Next slide, please. In the South African context, there's two types of registered designs. One is an aesthetic design and one is a functional design. Aesthetic designs are for articles that have features that are judged solely by the eye, meaning that it just has something that appeals to you. So there's nothing functional about those designs. It just looks really nice. So that's generally what aesthetic designs are trying to protect. So we have clients that are in the fashion industry, for instance, and they would file aesthetic designs. The requirements for aesthetic designs is the same as functional designs in respect of novelty and newness. So aesthetic designs need to be new in order to be protectable. So a world first, like in patents, and it needs to be original. And where originality comes in is that you need to have some sort of your own creativity and effort to come up with this design that you have. And the scope or the term of protection is shorter than that of patents, where you have 20 years of protection for patents. For registered designs and aesthetic designs in particular, it's 15 years. For functional designs, on the other hand, it's for articles that have features that are necessitated by the function that the article is going to perform. So it has a certain specifically designed feature, or the whole product is designed to serve a particular function. There is an overlap between aesthetic designs and functional designs sometimes, because you can have something that has a feature that's necessitated by the function, but the product also has aesthetic features associated with it. So a simple example will be that of a chair. You could have the chair that looks really nice, but it also has a specific feature of the backrest that has lumbar support. So now you have something that is both a functional and an aesthetic design. And you then, in that case, get protection for both. In terms of the requirements for functional designs, it's novelty, like for aesthetic designs and patents, in that the appearance needs to be a world first. And it needs to be not commonplace. So the appearance here needs to be almost not obvious to somebody who's relatively skilled in this field. So it's more linked to the inventive step argument from patents, as opposed to the originality requirement for aesthetic designs. In terms of the length of protection, it is 10 years. And it's important to note here that with aesthetic designs, functional designs, and patents, these timeframes are immovable. So once you pass these deadlines, or the 20 years, 15 years, and 10 years are done and dusted, you cannot go back and you cannot now try to extend it. It's almost open for the public to then use. So no one can then, so you cannot stop anyone from using these particular patented technologies and design rights that you have. Next slide, please. In terms of the timeline for registered designs, it's 6 months in most countries around the world from the date of you filing your South African application to then seeking international protection. And like patents, it's also territorial. So you only get protection in the countries that you seek protection for. In terms of that, it's important to note that in South Africa and a few other countries, it is possible to release your product to the public, unlike with patents where you have to keep it secret. Registered designs, you can release this product to the public and go back within 6 months to file a registered design. It's quite useful. And like I mentioned, some of my clients are in the fashion industry, and they would release a range, or they would release a product and wait 6 months to see how the market responds and reacts. And based thereon, they would then decide to go back and then file a registered design application within that 6-month period. So it's a useful point to note. Next page, please. So in terms of registered design protections, one can really protect anything. You could protect the new item of furniture, tire treads, shape of a car, anything that has an appearance, you can essentially protect it provided that it meets the requirements that I mentioned before. Graphical user interfaces, interestingly, can also be protected as registered designs. And the example that I give you here on the right is an example that Google, I'm using Google a lot today, as an example that they've used to file a registered design in the US for their landing page. Thanks. Next page, please, Suzanne. This is just an example of registered designs from one of our matters that we dealt with. It was a footwear article that Diesel came up with, and they asked us to register designs for them. And what they told us was that they didn't really want protection for the back of the shoe and the front of the shoe, but what they wanted protection for was actually, sorry, when I say the top of the shoe, sorry, but they wanted protection for the front and sides. So when we filed the design, we only filed for the front and sides of the designs. And what we then did is we proceeded with the design registrations accordingly in terms of an aesthetic design. Next slide, please. And here it's just another view so that you can see what we've actually filed for. Next slide, please, Suzanne. And it wasn't long before we filed those designs that there were infringing products on the market. And all of these products here, if you look at it, it all looks really different. But the fortunate thing is what we filed for was actually the front and sides of the shoe. So the red portion that we disclaimed from protection wasn't an integral part of the design. And what we managed to do with the single design application is alleged infringement of all 3 of these designs, and we managed to stop these infringers. So you can understand here that registered designs can also be quite a powerful tool and has quite a lot of benefit, provided that one is quite clever in the way that you strategize around the protection that you're seeking here. Next slide, please. The next form of intellectual property that I want to chat about is copyright. Now, copyright protection, I'm not going to dwell on it too much, but in effect, it's one of the forms of intellectual property protection that has no formal registration apart from films. So all these types of works that we are listed here, as long as it's an original work, you will get automatic copyright protection. Now, when we talk about original work in this context of copyright protection, we're talking about the fact that you had used your own steam and creativity and your own effort to come up with these works. Next slide, please. Now, in terms of copyright, there's a few things that one needs to keep in mind. And I think I mentioned a few of these, is that the owner of copyright is usually the author or creator of the work, except under certain circumstances. In addition to that, the forms of copyright that I listed there, and of course, this presentation is going to be shared with you so you can go back, but the forms of copyright, each one of those has different ways in which they come into existence. The authorship and ownership is also dealt with individually. And the terms of protection are also varying. And I just touched on a few of these here, but if you have any specific questions related to copyright, of course, we'd be happy to address them. But it's important to note that it's taken on a case-by-case situation. So there's the general provisions are really difficult to explain in the time frame that we have. But the few things that you can take away is that, like I said, the owner is usually the creator or author, except in the case of where you commission somebody to take a photograph or a painting, etc., where the person doing the commissioning actually owns it. And if it's in the course and scope of the employment. So if I'm a journalist, if I'm writing an article or I write a book and I'm employed to do so, it'll be my employer that owns the copyright. Copyright the length of time is longer than patents and registered designs. It's 50 years from the end of the year in which the author of the work dies. And in the case of software, it's 50 years from the date in which the copies of the software was first made available to the public. In terms of copyright in computer software, it's important to bear in mind that it only protects the code. It only protects the source code. So it doesn't protect you if somebody looks at what you're doing, reverse engineers it, and comes up with a competing software. It's the actual code that you write. So there's a few tips that one needs to bear in mind when dealing with these types of things with copyright, especially because it's not registrable, is that at any given point in time, you want to keep accurate records and verifiable date stamps to your code, just so that you can show third parties down the line that you have rights in this copyright in your work. Many years ago, what used to happen is that if you're a novelist or an author, you would send back copies of your manuscript to your lawyer, to yourself via registered mail, to quite a few people via registered mail. And if there's ever a dispute in terms of ownership and who owns what, the question, it effectively, the date is verified at that date. Also, it's important to know that when you're dealing with copyright, because of the ownership implications, when you contracting somebody to deal with copyright, or to deal with somebody to write something for you, or come up with a design for you, or to write code for you, you're contracting an independent software developer. Make sure that you have a written assignment of copyright. If you don't have written assignments of copyright, for instance, in the case of computer software, you don't have ownership of the copyright. And it's important to remember that. For those of you that are writing code, that are capable of writing code, etc., consider putting dummy loops in your code. It's a similar strategy that's followed by the likes of Telcom, for instance, because in their telephone directory, they have a few hundred fake numbers and names in that directory. And the reason is that if somebody copies Telcom's telephone directory and they say that they didn't, why would they then have these fake numbers and fake names in? Next slide, please. Thanks, Suzanne. So this is just some considerations when dealing with copyright, and these types of acts are not considered to be copyright infringement. So when you use study, criticism, or review, etc., it's the author and the source, the extracts, if you're going to use works from other people. That is important. And it's a similar sort of process if you are producing a lecture in public, etc. Next page, please, Suzanne. So I'm not going to delve into too many of these because they are fairly technical in nature, and I want to get to some angle is that copying three-dimensional products is not an infringement of copyright in the artistic work if the article has a utilitarian purpose and is made by an industrial process. Things like that are important. For instance, if you design a very great mug or cup, it's very artistic, creative mug, and I decide I want to, it's really cool, so I want to get it manufactured and get it produced industrially. I'm not infringing copyright. So whenever you see these types of things happening, it's worthwhile to perhaps contact a copyright specialist to get some advice on this. Similarly, if you put a product out there and you make a really technical product, there's a strong position that you would not be infringing copyright in that product unless you had the technical drawings from which the product was made. So reverse engineering is allowed. So you need to be aware that if you're putting a product out, reverse engineering is allowed in certain circumstances. So if you see a great product out there and you want to reverse engineer it to make it yourself, if you've seen a really cool product overseas, but you notice that it's not in South Africa, it's worthwhile to chat to us to see whether or not you're going to be stepping on toes. Next page, please. Sorry, all. I'm aware of the sound issues, and I apologize in advance. It's the network here that we have to deal with here. But this is drawing to a close in terms of the presentation, and we're just going to touch on trademarks. And the trademark aspect is the last form of intellectual property, and I almost saved the best for last in a sense that trademarks are effectively badges of origin serving to distinguish goods and services from those of competitors. And whereas the other forms of IP that I mentioned have a limited lifespan, trademarks last forever. So if you think about the trademarks like Coca-Cola, Mercedes-Benz, etc., I mean, they've been around for longer than I've been around, and they're going to be around for longer than after I'm gone. So it can be a very powerful mark, and you'd want to protect your brand, because in time it does become the most powerful IP out there. But it's tricky because at the early stage you have no rights in your brand, because if you say that you are about it, it's only over time and the value that you build into it that people start to recognize it. Insofar as trademarks are concerned, you already have common law rights, but you can also register a trademark and get register protection like you would register a patent or a registered design. In terms of common law rights, you'd see capital T, capital M that you'd put next to your brand. You can do it right now. Nothing is stopping you from doing it. Don't put the R with a circle around it unless you actually have a registered trademark. Because if you do put the R with the circle around it and you don't have a registered trademark, it's actually it's considered fraud, and there may be quite severe repercussions for you. So don't put the R with the circle around it by any measures unless you have a registered trademark. So put the TM next to your names and your brand and your company name when dealing with third parties, so that you're alerting third parties that you're at least aware of your common law rights in your brand. Common law rights are tricky because although you have common law rights, to enforce common law rights is hugely expensive and complicated. If you have, for instance, common law rights in Durban and you want to stop somebody in Joburg using Vishane's amazing company's name, I can't do that unless I would have to show that I have a reputation in Joburg. So I would have to get market research done, which costs hundreds, if not millions of rands in certain cases, to show that I have a reputation there. Whereas all of that is almost cut out if you have a registered trademark, where it doesn't really matter that you have to prove that you have a reputation in a mark. Next slide, please. So in terms of registering trademarks, any sign capable of graphic representation, when you have a brand name, it can be represented graphically by literally writing it down. So that's graphic representation. It can be used as a trademark. So anything with graphic representation and it can be capable of distinguishing goods and services what is registrable as trademarks. So it can be names, words, logos, shapes, container shapes, and combinations thereof can be protected by way of a trademark. So when selecting a trademark, I always advise clients to use, if you're going to use an existing word that has no relationship to what your business is doing. Think about Apple. It's an existing word, but it has nothing to do with computers. So it's a great trademark. Similarly, made-up words are also equally strong. Why would somebody infringe and copy your name if you made it up? So Xerox is another great trademark. So one needs to bear that in mind when branding your business. Try not to be descriptive. Don't call it an amazing product or amazing services. Or if you are having an app that connects people together, don't call it the app that connects people together. So don't be descriptive. I think Illo was a mark that was, or an app that was presented at one of the Innovate Durban presentations. I mean, that type of mark could be a very good trademark, especially because it's not a word that's a recognized word. And I don't think it can be, let's just put it this way, it can be used to distinguish goods and services from competitors. So things like that is something that one needs to bear in mind. Next page, please, Suzanne. Yeah, these are just examples of trademarks, and I'm almost done with my presentation, or the formal part of it. Like I said, it's just to touch on the fact that you can have words, color combinations, logos, etc. as trademarks. So the sky is the limit in terms of what you can protect with trademarks. Next page, please. Next page, please, Suzanne. Yeah, this is just an example from our files. These are just examples to show trademark infringements where the original product is on the left, the copied product is on the right. It shows you that with trademarks, it's not only, it doesn't have to be identical names that get copied. It's identical and confusingly similar names that get copied. So for instance, Handy Andy and Mandy and Andy's is not the same. Mandy and Andy's can be completely different. I mean, one could argue that it's a completely different trademark, but because it's so confusingly similar to Handy Andy, and if you look at the get-up of the bottle, etc., it's clear that these guys were trying to write off the reputation in Handy Andy. So here we were able to stop Mandy and Andy just based on the name Handy Andy. So it's important to remember here with trademarks, it's not just the exact identical name and spelling that you're protecting. It's the same name and spelling and also confusingly similar names and spellings, etc. Next slide, please. And this is just the last example of trademark to show you that here is an example where sometimes it becomes so tricky to see it. I mean, if you look at these two products, you really have to hunt quite carefully to see which is the original product and which is the fake. And the original product is, of course, the left, and the fake product is on the right. So here, sometimes even the entire get-up of a particular product can be constituting trademark infringement as well, or passing off. Next slide, please, Suzanne. So to just wrap up the presentation, and this is it from my side, and apologies for the sound, it's just to reiterate the fact that when we talk about intellectual property, it's not a specific legal term that's not in our lives. It's actually everywhere. And you can identify it in every single product that comes across or that your desk or you buy. Here, immediately, you look at your phone now, and it's hard not to see the trademarks in this phone that's presented for you. So then you can click away, but there's of course trademarks in the brand. There's copyright in the source code that's written here. There's registered designs in the actual graphical user interface of each icon. The actual phone shape is a registered design as well. You have patents in the technology that's within the phone, and so all of them, and then of course the trade secrets aspect comes in. For instance, in the distribution channels, and that's the last form of IP here, whereby you have the know-how associated with actually building this phone, that Samsung package. And I always say that use these forms, all forms part of the strategy, where you'd want to protect yourself in the initial phases at least to grow your brand, which over time becomes the strongest form of IP. So thank you all for that. Like I said, technology works, it works. If it doesn't, we have to deal with it. But thank you all. I'm just going to the questions here. Let me just quickly
Thank you,
go through
Shan.
them.
Sorry, I
Yep.
did let you go on because I know there was some sound issues, but I think it was of great value as well. I'll go through the questions. I think just the first few just comments as well. So there's a question regarding from Lanchla around when you give a lecture, how can you protect that? So that's an
Give a lecture.
Yeah. So if
you wouldn't.
Yeah.
Yeah. So in terms of that, Nashlancha, you could be able to protect your materials. All the materials that you present are copyright protected insofar as you've come up with it. So your slides, your notes that you would decimate, etc., all of that is protected by way of copyright. Actual content itself or ideas that you throw out, those things cannot be protected. Ideas cannot be protected by any form of IP unless it's reduced to some form of form. So meaning that you write a book, you present, etc. So that's the form of IP would be applicable to lectures.
Sure.
Thanks, Suzanne.
So I'm going to go through the questions. Your sound is breaking up a little bit, but we do have all the chats. We are able to, some sometimes I think we're grateful for technology because we can download all the chat, question and A as well. And then we can actually send that to you when we can reply to them. But let's try to go through the next question. An inventor builds a mock working electronic prototype by his or herself to ensure in the input and output is correct. The inventor then passes the mock prototype to an electronic engineer to reverse engineer the invention. Can the electronic engineer doing the reverse engineering now claim the electronic design IP, or is this design, will it still belong to the inventor?
Reggie, this is a great question, and I often charge for this type of answer, but it's, you know, it is a tricky one, and it's not the, you know, it would depend on the factors surrounding the disclosure to the electronic engineer in question. At the outset, if you give the mock prototype to the electronic engineer, and it's doing, let's just say it's you build a filter or something like that, where you have an input, you have an output, and the filter that you build is very unique to yourself, but you just wanted it to fine tune maybe the electronics in there. So you invented it. You as the inventor are the only person that is enabled to claim or to file a patent for that invention, irrespective of what it looks like. The engineer will only be able to claim protection or claim that he owns anything is the fact that he, or anything that he's added that you did not add, and that any electronic engineer would not find novel and obvious to add. That's what they would be claiming protection for. Also, in terms of the design, if they lay out and design a PCB, for instance, that's a printed circuit board, people. Hello? Can you hear me?
Yes, we can
hear you.
Yep. Oh, sorry. So the printed circuit board, for instance, the design engineer can potentially own the design in the printed circuit board unless you right at the outset make it clear to the electronic engineer who owns what. That is why I always say that in a perfect world, you know, everyone would be above board and lawyers wouldn't have jobs. But we don't really live in a perfect world, and that's why it's important to set out everything in writing before you engage with people like this. If you're getting an engineer to do testing or more R&D for you, set out at the outset who you expect to own what, instead of having to fight with it later on, because that's when you're going to have to incur major costs to try to unravel something that could have been sorted out right at the outset. Thanks.
Okay. Cool. And then I think Reggie followed on with the question to say, after the patent is granted, should an inventor receive a certificate, etc.?
Yes. You will receive a certificate. It does take some time. But you will receive a certificate. There is a backlog in the South African Patent Office. Suzanne, I can't see the question, so I can skim through them here. And I see here that an anonymous attendee has a South African patent and no PCT. Can he license his technology to other countries? So yes, in terms of contracting, it depends on what you license. Here, you're not allowed to license the patent because there is no patent in other countries. So what you can do is license your technology in the form of the know-how, etc. with them. And it then boils down to a case of what you are contracting for. You know, in that particular instance, I would then say, if you find a licensee internationally that are interested in your technologies, maybe then chat to an attorney to see what rights you can then license. Because in terms of not having a patent in these countries, you can't then now tell them, well, I have a patent in South Africa, and because I have a patent in South Africa, you can't do X, Y, and Z in America. So that's basically what I would suggest. Hello?
Yeah. Yes, we can hear you.
Okay.
Yeah.
I just have to check.
No.
So can you do a patent for a software design? In a nutshell, if it has a technical effect, Bangamusa, you can. But it's important that we need to know what the software design you're talking about. So if the software design is a software like a piece of code that doesn't really have any real world interaction, it's like an abstract idea, it's a software that maybe is a screensaver or something like that, it doesn't really have any technical real effect, then it's really tricky. So bottom line, when dealing with software, you can patent software, but under certain conditions. So try to find yourself a patent attorney that has either a software electronic engineering background to actually just maybe have a look to see what you're doing and comment on it. And I think that when you followed up that question of what kind of IP do you need to file for a software design, if it meets the requirements for patentability, the strongest form of protection is going to be a patent, because what the patent tries to protect is actually the underlying algorithm of what is novel and inventive, not necessarily the code itself. Whereas copyright protects the code. And those of us here that have experience in coding know that you can have an algorithm that can be coded up in a million ways if you factor in all the types of languages out there and the different styles of coding. So each one will have its own style and own copyright protection in itself, but the same algorithm applies. So the algorithm is protected by a by way of patent. You cannot protect the algorithm with any other form of IP. Then, of course, the trademarks. You'll protect your trademark by way of, you protect the software by way of trademark. Microsoft Word is a copyrighted, it's a trademarked software package. So you'd have a combination of these. And I saw a comment, it's probably later down, regarding the best way to protect an algorithm. I always use the example of, if you can keep it a trade secret, by all means do so. But bear in mind that if it does become quite commercially successful, if there is a chance that you have, I always use the example of having a competitor with unlimited resources, will they be able to reverse engineer what it is that you're offering? What is the, if they, let's put it this way, if they can reverse engineer what it is that you're doing, then they are able to, to come up with this. And keeping it secret wouldn't necessarily help you. And that's where perhaps the best shot would be trying to protect it by way of a patent. Certain things like the formula for Coca-Cola, etc., that's easier to keep a secret. And I think it really is dependent on the industry that you're in and the actual code that you're writing and what it is that you're doing. So that's the questions from Bongo Musa. I'm just going on to Marco's question. What is the cost of registering a trademark? Marco, the cost of registering a trademark, I think it works in terms of classes of protection. It's about 5,000 Rand per class that you are looking to register a trademark in. Okay, thanks, Reggie. Intlantla, have a startup and want to know how important it is to have something signed if you work within government. So Intlantla, I would say that it's always first prize to have something signed if you're working with any party. Doesn't matter whether it's government or any other organization. It's really good to have something signed, especially if you are engaging with them for selling them something or providing a service offering to them. So it's a different story if you are engaging with your banker or maybe your attorney or something like that. But maybe your banker, you'd maybe need to have an NDA. But I'm not sure. In terms of having something signed, I always say it's just best practice to do so unless you are quite confident that you have your insurance policies in place, etc. If you file, for instance, for a patent, you then at least can rely on your patent if there's infringement. So then you wouldn't necessarily have to have a contract in place. I often have clients, for instance, that want to pitch products to government, but they're scared and unsure whether or not to do so. And even to Fortune 500 companies, for that matter, it doesn't have to be government. And what I always say is that if the party that you're disclosing to doesn't have the authority to sign an NDA, or they don't want to sign an NDA, you only have two choices available to you. It's either you take a chance and disclose it to them and take it as it comes, or alternatively, you try to file a patent for the technology, and then when you meet with them, you almost use that as this bargaining chip. When you go into the meeting, you say, I've got a patent pending on this technology. So right from the outset, whoever you're disclosing it to knows that you mean business and you're not willing to let your IP just be taken away. So that's important to bear in mind as well. I'm just going to go down here for more questions. I use a number for my startup. Is that fine? Numbers should be fine, provided that, Insha'Allah, it's going to be the same question, whether it's capable of distinguishing your goods and services from your competitors. If I'm selling a cool drink and I call it, 664, whatever it is, but that type of thing could potentially be protectable, provided no one else has done it. So a number can be done, provided it's not related to your goods and services that you are sending. How long does trademark, when applied, take to be registered? Okay, so Vimani, it's actually a long process, and it's because of the backlog at our trademark office. It takes between 2 to 3 years. You can understand that it's a bit of time. You have registered trademark and received a confirmation, but you also applied for a logo to be trademarked. You're not received any communication regarding the logo and regarding the name. Only confirmation was received. Money, it depends on how long this takes. It's quite common for the trademark office in South Africa to take years. We do have a backlog. I think it's between 2 and 3 years right now. So it's not unusual that you are experiencing this backlog. But I would just hang in there. I think the main thing with trademarks is that who was first in the queue. So if your trademark is first in the queue, you're going to get the rights. Okay, I'm just going down. How much is the matter of registering IP to? How much is the matter of registering IP? I'm not too sure, given if I'm understanding your correction correctly, but I can just give you anecdotally some of what my clients do. So, for instance, when I say that it is costly, you must realize that these things here have its place and its context, and you need to figure out how you're going to work it within your own business. And I think this is almost where the strategist in the business person in you comes out, where you now need to know that, look, these are the IP tools that are available to you. These are optional tools for you to file. You don't have to file for any of these. But how do you now best protect your business going forward with these tools that you know that you need to get protection for? And I think that is the question. And in terms of a deterrent, I can tell you this much, that, from experience, people are less likely to infringe something that they know is protected, especially South Africans, than they are to have, just gun-ho go and copy anything. And I think that benefit that you get in the deterrent value is very difficult to quantify. I have a client, for instance, that I tell him, look, you're wasting your time filing a patent, because I don't think it's gonna be, or let's put it this way. I tell them that South Africa is not going to examine your patent, but for me to argue that you have novelty and inventive step is going to be so difficult. But the guys file it anyway, and I ask them, and the reason for them to do it actually is the scare value. They say spending the 20-odd thousand rand to file a patent application is cheaper than taking out an ad in the Sunday Times. And it's lasts for the year. He can tell his clients and his competitors that he's got patent pending. They're scared to come into his space. His clients think he's doing something amazing because he has a patent pending. So he uses it as a marketing sort of strategy in a sense. Yes, we out of ethical reasons will not file a patent if we don't believe there's at least something to it. But a lot of the times it is something very thin. So you can potentially file a patent, but the choice is yours. And that's what I'm trying to get at. You need to decide how you're going to best use this form of IP and whether the costs justify you spending money to do it. So I'm just quickly going to go through more questions here. How do you protect a mobile app or a portal? Okay, so Molefi, in terms of protecting an app, you would already have copyright protection in terms of the software that you've written for it. Make sure that if you get external developers to write the code for you, that you have agreements in place to who owns that copyright in that code. If you use open source, and this is a common thing that people get wrong, open source is not free. Open source comes with a license agreement. So if you're using open source, it's fine. Just make sure that the license agreement it comes with is not too onerous for you. So that's what you need to remember when dealing with software. Insofar as the patent is concerned, it could potentially be patentable if it's an app, provided it has that technical effect, like I mentioned. In terms of the other form, which is probably the most important form in terms of the app, would be the trademark, because that's the first thing that people are going to see. I'm sure that no one of us would have thought that let's go look for Uber's app in terms of a geophysical location matching system. If you try to search for that, you're never going to find Uber. And most people in the world don't know Uber as that, but they know it as the name that it's called as. So that's why your name and your brand for your app is very important here. So Sidwell, you can get in contact with us via Innovate Durban. We normally have a situation where if you come to us directly, odds are you're going to get our full-on cost, which we charge the general public. But in terms of Innovate Durban, where we're dealing with startups, it's part of our initiative whereby we try to assist as much as we can by bringing the costs as low as possible to assist startups. So I would say that get in contact with the team at Innovate Durban. They're fantastic, and they have experience in connecting you with the right people. But yeah, so I think that's so Molefi, you just mentioned here that you've use open source. Like I said, just make sure that the open source code that you're using doesn't have onerous nasties. You'd be surprised some of these open source license agreements. Some say that if you use just like 5 lines of code of their code, you have to now release your entire source code for everyone else to use. So that's not, I'm sure, not the intention for a lot of inventors and innovators. So remember that. Just enter into these things with your eyes open. That's the bottom line.
Thank you so much, Vishen. Sorry, I know I allowed the time to go over just because I think it's really valuable that everyone on the call got the answers to those questions as well. So we over time, so I do apologize, but I think a lot of people found value. I do want to say thank you again so much to Vishen, not only in terms of sharing his expertise, but valuable and also otherwise costly advice that like we're saying, if you'd have to go through the normal process would be really difficult. So I think you've given us a really good overview in terms of various aspects in terms of IP, trademark, copyrights, and that which they can use in terms of determining what the best solution and way forward for their businesses and startups are. So a huge thank you to you for your continued support and relationship with Innovate Durban as well. You would have seen that Nosipho would have launched a poll a little bit earlier. For those of you that still have it on your screen, please can you complete that for us so we can provide you with better service in the next webinars as well. Our next webinar is scheduled for the 19th of November. We're hoping to host one around cybersecurity because we think it's really an important aspect that we need to look at now, especially with people working remotely. Together with the convenience of using so much of services online now as well. I think it's a huge part of that. So we will be sharing details of that in the coming week as well. And so thank you all for attending. I see all of our participants stayed to hear the answers to the questions, which is great. Like I said, I think we allowed it to go over because of the value of it as well. Nosipho will be sharing the presentations with those participants that attended, together with details. Like Vishen said, you're welcome to contact us for support regarding that. Thank you to Aurelia for joining us on the webinar this morning as well. Well, it's midday now. And yes, stay in touch. You would have seen details earlier when we started off for our Innovation Collab as well as Innovate Durban. You're welcome to contact us. You can also use our general email for all queries, which is info@innovate.durban. That's info@innovate.durban. Thank you, everyone, and hope to see you all at the next webinar.